All right, good evening. Welcome once again to the OASIS Working Group, a subdivision of the OASIS Helpers Group. This is our second video. It's being recorded on the 24th of January. I suggest, if you will, just to pause and read our disclaimer so that you've read it at least once. It will appear on all of our videos, and it's important. With the exception of our guest this evening, none of us are attorneys, and so consequently, nothing that we offer in any way, shape, or form should be construed as legal advice. And in fact, our guest, although he's an attorney, is not likely to be offering any sort of advice on any of the videos either. I'd like to invite you to meet our guest. His name is Brent Allen Winters. He's the author of Excellence of the Common Law, among other books. This is the very finest book on the history and development of the common law, which is the foundation of the American law system, probably in publication. It's an extraordinary book. I invite you to read it. Just for a moment, let me stop the screen share for a second and let Brent introduce himself quickly. Brent, if you will.
My name is Brent Allen Winters. You can find me at www.commonlawyer.com, and I'm from downstate Illinois, and I practice law in other states and federal courts, and I'm involved as now a power of attorney in this case, OASIS case, for the lenders, the folk that the government call investors. Regardless of the label, there are people that put money into the investment of OASIS and have lost a lot of their money. We hope, of course, they'll get it back. But this case is supposed to be about the receiver distributing the money fairly to those that have invested money. That's going beyond my introduction to me, but that's how I'm involved in the case. And I've been involved in it for a couple of years, at least.
Thank you, Brent. If you'd like a more detailed introduction of a similar kind of our other panelists, I invite you to go back and look at the beginning of video one. The panelists are Joe Paniagua, who was instrumental in working in the back office for OASIS, out of New York. His brother, John, did a great deal of programming for OASIS to simplify access for the lenders. Jason McKee was a very substantial lender himself, as John was, and became very, very instrumental and involved with assisting other people to become involved, and therefore has taken some personal responsibility for helping them get their money back. Was very instrumental with Brent and I back when the claims process began in May of 2020. Finally, myself, Greg Millick, I work now as a paralegal for Attorney Winters and assist in all methods that I can to do, as Brent said, to try to help recover for our lenders everything that they invested. So, that said, let's go back to sharing our screen. And so, as I was saying, Brent is the author of Excellence of the Common Law. I highly recommend it to you. It's actually compelling reading, in my opinion. And if you want to know about how this country got started, its foundation of its laws, and the difference between those and civil law, first instituted by the Babylonians, carried through to the Greeks, and finally institutionalized by the Romans, which is in effect, for shorthand, sort of law of the city. A great many people are gathered together, and they do not have natural recourse to the resource of the land that God provided them. They tend to need to be governed in a different fashion than the common law would otherwise provide. Those distinctions are extremely important. We do have elements of both common law in operation within our country. The Constitution itself is a common law document, as were the Articles of Confederation. Particularly since the Roosevelt administration back in the early 1940s, we have expanded into a great deal of civil law. It complicates things quite a bit. So This evening, we're going to be talking about the cause of action, and we're going to specifically about the elements. Every lawsuit must state at least one cause of action that's recognized by the court where it's filed. This is the very beginning of a process where they issue a complaint and they identify their cause of action. The essential ingredients to a lawsuit are called the elements of the cause of action. Each cause of action requires that a specific ingredients are included in the allegations of fact that purport to state the cause of action. These are the elements of that particular cause of action. And so you can have causes of action for robbery, embezzlement, fraud, things like that. We'll be focused mostly on the elements of fraud specifically, since those were the heart and the elements of the cause of action brought in our case. If the plaintiff, the person bringing the cause of action, fails to state all of the specific elements for that particular cause, then the plaintiff has failed to state the cause of action itself. Mike DaCorta, who is the CEO of Oasis, was tried on 3 counts stemming from fraud. Fraud was the primary cause of action against him in his criminal trial. Now, in order for a plaintiff to sue for fraud, that is to have a cause of action, then the defendant must have done more than make a false statement. In order for a cause of action in fraud to be actionable, in other words, for the court to adjudicate it and entertain it, it is necessary that the lie be coupled with other elements. The elements of a cause of action for fraud are, and we're going to get into those, but note as we go through these, there are 6 of them. The defendant in this particular case was Mike DaCorta. So when you see the word defendant, think Mike DaCorta, and the plaintiff in his criminal trial was the United States of America, the U.S. government. So the first elements of a cause of action for fraud are the defendant makes a false statement. Just before I go any further, Brent, would you like to comment on the whole concept of causes of action and the elements for cause of action?
Well, first of all, able to listen to you go through them. It's a good review, I suppose. But it takes more than just stating the elements. Yes, that's true. You got to state the elements, but you've got to state facts in your complaint that fulfill those elements. In other words, you have to allege the prosecutor in this case, which is as the plaintiff, but in a criminal context. This was a criminal case. That means they're going to take the life, liberty, or property of the defendant if they can, or some combination thereof. And that's what they've ended up doing. They've taken his property and they've taken his liberty. And of course, that has a lot of a detrimental benefit to one's life. Those three stand and fall together, and that's what they're after there. When a prosecutor brings a criminal case, he's after life, liberty, property, or a combination thereof. And in order for him to prevail, the prosecutor in this case, as a matter of law, he would have had to have stated all the elements of the crime. In this case, it was a matter of what they said was fraud, and there are specific elements. And each one of those elements, he has to allege in his complaint in order for him to get past the threshold of the judge and get it before the jury. The law says he has to allege that the defendant, Mike DaCorta, violated each one of these elements and must prove that he violated each one of these elements beyond a reasonable doubt. When I say that, I mean separately. Each element must be proven to the jury that he violated it beyond a reasonable doubt. That's a standard, if it's followed properly, that is high enough that if it were really adhered to, there'd be very few criminal convictions. If a case does go before the jury. It's been my experience that jurors don't give much thought to it or don't understand it. It can be elusive to understand what that means. What that means is the juror has to be able to say, well, I've got a doubt about this of 6 elements or 7 or 3 or however many elements there are in the crime. I've got a reasonable doubt whether he's guilty of that one. It's not a strong doubt, but it's a reasonable doubt. Well, if that's the case, then the law says that the juror is to acquit the defendant. It doesn't happen that way very often. There are those rare cases. It also comes down to, the jury, of course, doesn't have to explain any of the reasons why they did anything. So we don't know why they do what they do, and they're not required to tell us unless one of them chooses to. But in these cases also, there's a lot of human elements involved. Men are not machines, and jurors are not machines. Certainly, even judges and lawyers, believe it or not, they may be hardened to what goes on and just too used to it. Matter of fact, they are. That's why we ask the jury. We don't ask the professionals, we ask the jury. The professionals are just too hard to it, they're too used to it. And the jury brings something that the lawyers and the judges and the police officers and the prosecutors cannot bring. They bring their guts. They bring their guts. And that's what we want. That's the one thing that the experts can't bring. And your guts takes in a whole lot of stuff, more than you can describe. But that's what it comes to, and it comes to this also. The jury has to be persuaded. No, let me put it this way. There's something to be said for the winsomeness of the defendant, and more importantly even, the winsomeness of the defense lawyer, because the jury will attach their like or dislike of the defense lawyer. They'll attach it to his client. That's the reality of the matter. One more thing I could say while I'm talking about it, Greg. It's not the job of the defense lawyer to prove innocence. As a matter of fact, the law doesn't require it. The law doesn't require the defendant, in this case, Mike DaCorta, to prove anything. The law requires the government to prove beyond a reasonable doubt, and the standard and the bar is very high. But the only thing that a defense lawyer can do in such a case, but this is powerful, a defense lawyer doesn't have a case to prove. People think, well, I need to present my side of the story. No, that's not the way it works, and it doesn't work to do that. You don't want to present your side of the story. You want to weaken their story. That's all you want to do. That's all that you can do, but doing that is a lot. And if you weaken their story, that means you provide those reasonable doubts, you see. That's all the defense lawyer needs to do, is to provide reasonable doubts at every point. He's not got any burden to prove anything, and if he goes into the case to try to do that, he'll lose before he starts. Just present doubts, and that works best too in front of the jury, for sure. Well, that's just some rough overview from my own experiences, which are not the experiences of other lawyers. They're mine, and that's the conclusions I've come to for what they're worth.
Thank you, Brent. Let's continue with the other elements, and then we can discuss them in toto. All right. First of all, Mike was accused of making a false statement. Obviously, it had to be some kind of a significant false statement. That alone doesn't cause an action for fraud. The false statement concerns a fact, part of the plaintiff's damages. Now, the plaintiff in this case is the U.S. government. They're claiming damages of some kind. We'll talk about what that might be or might not be. Thirdly, the defendant knew the statement was false when he made it. We'll be discussing later on in this series as to what the prosecution presented as his false statement and how they allege that he made those false statements and so forth. And number four, the defendant intended that the plaintiff act in reliance on the false statement that he had allegedly made. Fifth, the plaintiff reasonably relied on the statement and acted upon it. So the damaged party heard this lie, took action based upon the lie. And sixth, the plaintiff then suffered damages by relying on the false statement. Okay, this is definitely worth a discussion. The question will arise as we go through the case. What was the false statement that Mike was accused of making? What harm did it cause to anybody? And in other words, the number 6 here, the plaintiff had to have suffered damages by relying on the false statement. So Mike could have told everybody that his car was white and it was actually silver toned, and it would have made no difference. And if someone had acted upon that and bought a white car thinking they were mimicking him, that was not a harm, and it was irrelevant. So to bring an action for fraud, all 6 of these, as Brent said, every 6 one of these elements had to be fulfilled for the cause of action to go forward. And there had to be allegations that, or if you will, subjects or subject matter brought to the forefront to substantiate that each one of these was in fact fulfilled. Those are the 6. Okay, you guys have any questions about what we've done so far?
Quick question. The 6 elements, or do they get explained to the jury by the judge? Or what's the expectation of the jury to know the 6 elements? Or do they?
Okay, what happens is if the defense lawyer knows what he's doing, he'll get a copy of the model jury instructions for this case, and he'll work backwards from that. In other words, the model jury instructions are going to be taken in the end, and they may be tweaked here and there, but they'll find the jury instructions that apply to these so-called Ponzi scheme cases. That's a particular species of fraud. And there's model and jury instructions in authoritative books that come from the state bar. They've got some expert lawyer, that expert of experts lawyer that draws up jury instructions, is in tune with these elements, and he'll take those and he'll say, okay, here's what the jury is going to look at the very end of the case, and I've got to make sure that I squelch each one of these at some point in the trial, or if you're the prosecutor, make sure you fulfill them. But you get the jury instructions, that's what's going to be at the end, and then you work backward through the case and you say, okay, I'm going to have a witness to stop this point, I have witness to stop this point, and while there's cross-examination going on, there may come an opportunity where you can do that. But the jury will hear the case. They won't know much of what it's about at all. The lawyers will stand up, they'll make opening statements, and they'll provide a roadmap of what each one of them, what he says he's going to do. So what it comes down to, the big picture is this, like we were taught when we were in school in composition class, or at least I hope we were. I didn't catch on to this till later myself. You say what you're going to say, you say it, and then you say what you said. That's what a trial is. And each lawyer will stand up, and if he knows what he's doing, he'll say, here's what we're going to do in trial. Here's what we're going to show you. And we're going to bring forth evidence that's going to show this, it's going to show this, and this. Now, the other side is going to say this, this, and this, but we're going to show that's not true, however they do it. Right. So you tell them, you give them a roadmap, you tell them what you're going to do. You try to get them interested. Because if they're the biggest crime you could commit in the trial is to bore the juror. He won't like you for it. You got to keep things moving if you can, and tell a story. Stories sell. You just putting the facts out there, tell, but it won't sell. You got to sell your point of view. So by the time then you tell them what you're going to do, then during the trial you try to do what you said you're going to do, and you better deliver to a substantial degree, or the jury will think you're a liar. And then when it's all over, you make closing statements and you try to tie all of it together. Then after that, both sides rest. And then the judge and the 2 lawyers, or however many lawyers there are, they get together back in the judge's chambers and they have a serious powwow about what the jury instructions are going to say exactly. They've got the model jury instructions there, wherever they got them, some authoritative book someplace. And then they start saying, but this case is a little bit different. This jury instruction needs to be tweaked a little. And then the judge will make a suggestion, or the 2 lawyers will make a suggestion, or one of them. And if they can't agree, the judge will decide. He's the umpire. He'll make the ruling. Now, isn't it something? You go to a criminal case. What's a criminal case about? Well, criminal case, by the time you go to trial, there's a disagreement about what the truth is. Truth? Yeah, that means facts. What happened? Who done it? How did he do it? Where did he do it? When did he do it? That's what the trial is about. The trial is not a lawsuit. We call them lawsuits. They're not lawsuits. What are they? They're fact suits. Fact is not some things, it's everything. The jury doesn't know the law. The jury doesn't care about the law. What does the jury know? Well, either somebody got screwed out of money or they didn't. That's all they know, and that's all they need to know. Prove it or bring doubt to whether or not those facts are true. The law is not an issue. You got all these fancy federal statutes. Any good lawyer go and he'll read them, then he'll put them aside to say, okay, here's what we got to do, because you're dealing with the public. You're dealing with Joe Q public. You're dealing with the salt of the earth here, hopefully. Folks that get horse sense and guts. And they have lived life, and they know what a lie is, and then they know what business is, and they know what an agreement is. Well, the whole idea then at the end is those jury instructions come up, and you got three lawyers, including the judge, and then other people in the case, they can't agree on what the facts are. And that's what this is all about. And then they'll send the jury back, and those jury instructions will say, okay, decide what the facts are. If you decide this way, that the fact is this, then you're supposed to bring in a guilty or a not guilty verdict. But it all comes down to the facts. And by the time the jury gets the facts and they decide what the facts are, it's their prerogative to do whatever they want to do. They can bring back, as the Supreme Court has said, that they can bring on more than one occasion, they can bring back a verdict in the teeth of both the facts and the law. And that's the way it works in America. Only in America, well, the English-speaking world, do we have trial by jury. And the jury is the final arbiter of right and wrong in individual instances from whose decision there is no appeal unless the course of the common law was not followed. If you can show that happened. But it comes down to facts. I guess if I could stress anything, Greg, it's not a lawsuit. We call them that. That's not what it is. It's a fact suit.
So let's go through these elements and sort of play a little game here. So Mike is accused of making a false statement. So the prosecution is going to have to bring out evidence that he made a false statement. They actually spent a great deal of time, as we'll see, stating that, well, more importantly, in their mind, he failed to state something that they felt was sort of fraud by omission, that he didn't bring forth this National Futures Association agreement that he had. He didn't really make a strong case that he made any false statements. And in fact, I think they played recordings, which we'll hear or listen to parts of transcription of, where other people were talking, not Mike. So we'd like to know, this is a question I'd like to ask, I need to ask you, Brent. The government here is obviously not damaged, and yet they're the plaintiff in this case. How does that work? I mean, we know of no one to date, as of today, who was harmed by any action on the part of Mike DaCorta or Oasis. Every witness that got up there could have been asked the simple question, well, you know, you just retailed for us that you lost money or that you've been set back or what have you. Did that happen before or after the government shut down the company? And all of them, everyone without exception, would honestly have had to have said, well, it happened after the government came and shut down the company, because no one registered a complaint against Oasis in its entire history until the government did. And there was no harm done until it did. Also, another omission they'll say is, well, Mike was saying that he was a successful Forex trader. He did not reveal. Another omission. He didn't tell anybody that he had lost a lot of money. And we'll get into that too. So Mike wasn't thinking in any way, shape, or form that these omissions were significant or pertinent to the lenders for reasons we'll discuss. So he the defendants were acting in the void of these statements, if you will, more than on any statement that he may or may not have made, most likely. So, Brent, how can the plaintiff in this case, the U.S. government, how could they have suffered damages? That doesn't seem to fit.
Hey, can I add something before chimes in as well?
Sure.
So also in that case as well, the person from the CFTC who actually filed the complaint, who was the one saying that there was false statements made and all this in the beginning, or that there was some kind of action, they never testified in this case. The actual person who filed the complaint, correct me if I'm wrong, never testified in this case at all. They were never brought to the stand and asked, why did you even, what caused you to make the complaint in the first place?
It's a great point.
You know, when I first heard about this case, I was looking for somebody that had been damaged before the government came charging in, guns blazing, and confiscated everything. And I'm like you, up to this time, I haven't heard anybody complain that they'd had their money stolen by anybody except the government has made it miserable. And a lot of them have lost business opportunities and lost lost their health because their retirement was wrapped up in this. And from what I understand, reading the trial transcripts, the evidence was weak. Did the jury do their job? It doesn't look like it. No, the jury is the jury. But I don't see proof beyond a reasonable doubt. Of course, I'm evaluating it from a distance. There's, as I'd said before, there's something to be said for being there in person. That's what it's all about. Trials are personal matters. Your confrontation of witnesses, looking at expressions, getting the feel of the presence of the people that are involved in the case. That's why the jury is right there. So I can't second guess what happened at the trial. Reading the transcript doesn't give us all of it. Some of you were there for part of it, but it didn't look to me like there was the facts of fraud were proven. And I didn't see and haven't seen that anybody was complained about being damaged. You know, there's some crimes that can be committed without any damage at all. If you fulfill the elements of the crime and there's no damage, it's still a felony. Some crimes are like that. You know, burglary is like that. Burglary has elements. The breaking and entering, that's two elements. Of the dwelling house of another, that's another one. At nighttime, that's another one. With intent to commit larceny or felony therein. About 5 elements. But you can break and enter a house with intent to commit larceny or felony therein and be guilty of burglary at nighttime, the dwelling house of another, and be guilty of burglary and walk out of the place and not damage anything or take anything. It's just the intrusion that's criminal, you see. Well, in this case, though, with fraud, it's a different crime. There has to be damages with fraud. If there isn't, then it really isn't fraud. Now, some people will say, well, the federal government says that, according to the Securities and Exchange Commission, that you don't have to have damages. Well, I know that. But of course, that just leaves it wide open, which it often is, to go after people and accuse them of anything. But that's not right, and the court shouldn't uphold that. In cases of so-called fraud, there must be some kind of damage.
And this was
back to you, Greg.
This case was brought by the Commodity Futures Trading Commission, not the Security Exchange Commission, and there were no securities involved. So that wouldn't pertain here either. We are at a loss to determine who was damaged by this in any way, shape, or form, other than after the government intruded and began seizing property, liquidating property, all without there having been discovery or hearing or adjudication as to whether the company had even done anything illegal. And they simply suspended operations in the civil case for 3 years in order to get a prosecution of Mike. And there's an awful lot of, as you were discussing before, there was an awful lot of, there's a high degree of emotional persuasion going on the floor between the witnesses and the prosecution attorneys and the defense attorneys. They're both trying to make an emotional appeal indirectly to the jury, that the jury will buy their representation that in fact there were damages, there was a lie pertinent to the damages, and people were harmed, and so on and so forth. And so you had on the one side the prosecution attorneys trying to make the case. We'll go into this in our next video. As we go through there, we're in the end, after the complaint was amended and superseded, a superseding of complaint came in. It ended up originally with 2, and then the superseding indictment included 3. And these are the counts that were brought in the indictment against Mike DaCorta, for which he was tried last April of 2022. Conspiracy to commit wire fraud and mail fraud, which is actually boiled down to Title 18, United States Code, Section 1349, which was attempt and conspiracy. We'll cover some of that in our discussions. Count 2, and on that part, they had 13 very specific allegations to support this particular count. That they said, oh, well, this happened, that happened, and the other thing happened. And they labeled 13 different things. We'll cover that in one single webinar. Count 2, illegal money transaction in violation of Title 18 of the United States Code, Section 1957, which was that the accusation that Mike had engaged in monetary transactions in property that had been derived from specified unlawful activity. So it kind of relates back to count 1. So the illegal activity was the commission of wire and mail fraud, and that produced access and ownership to property through an illegal process, and brought on count 2. Count 3 was later added, that Mike had made a false and fraudulent statement on an income tax return, basically on his declaration under penalties of perjury. And that's what this case is all about. We will go through great detail in each one of these. Count 2 and count 3 don't need to have and didn't have much subtext to prove their point. So the prosecution really leaned very, very heavily on trying to prove count 1, and then and persuade the jury that all these things had happened, all the elements had taken place, and the defense was charged with the responsibility to convince the jury that they had not, or to at least give them a reasonable doubt that they had. And that's where we're at. Gentlemen.
On the count 3 for the false and fraudulent income taxes, that's personally against Mike. That's not against Oasis as well, correct? That would have been nothing that would have held for the shutting down of the company because of him filing a false tax return of his own personal taxes, correct?
Yes, that would be correct. And even on count 1, if Mike had committed mail fraud and wire fraud on his own and done that, but there had not been damages to the lenders as a consequence, that was the 6th element that was required in effect. You have to look at the government as a stand-in on behalf of the U.S. citizens that may have been damaged if this has been allowed to continue and so forth. I suppose they're acting as a proxy here, which is kind of a strange thing, since there wasn't, as far as we know, there may have been, we just don't know who the original complaint was lodged by, or for what reason, on what grounds. We never got that at all. So prosecution kind of had to make stuff up, and they did a really good job of it.
Can we find out by FOIA who is that? We can find out by, submitting a FOIA, find out, is that possible?
Brent, how could we find out who the original complaint was lodged by? If it was, in effect, it had to have been one of the lenders, one of the so-called investors. How do we find that out?
Well, you don't know. You don't even know if there was a complaint from any of the lenders. it could have been that the prosecutors just decided they wanted to go charging in and do what they did. There may have been a complaint, or they may have construed a complaint that wasn't a complaint, but all they have to do, all the prosecutor has to do to get an indictment, he's got to have an indictment of some kind, is to go in there and get facts that amount to probable cause. That's how they got the warrants and everything, I guess, and convince some neutral and detached magistrate, a judge that isn't involved in the case, that there's evidence of a crime. And at what level is it? One thing I could bring up here too, I don't know, I suppose it was a grand jury indictment. I guess I never thought about it. Would have had to have been.
It was.
But yeah, the grand jury, the standard for grand jury I'm sorry, go ahead.
No, but I can guarantee you, to get Mike's indictment, Joe Neely already had pled guilty, and they probably offered his testimony as fact to the grand jury.
Mm-hmm.
That's on the criminal side, but what about on the civil side to get the subpoenas? Do they need a grand jury indictment on the civil side just to go ahead and shut the company down?
They would have, I don't know this. I'm not an expert on that particular kind of agency law. I'm just assuming from experience with the IRS and the SEC that they would have that power. But I was going to make the point about the grand jury, that the standard for grand jury indictment is the same as for conviction, beyond a reasonable doubt. And if the grand jury isn't convinced that a crime was committed beyond a reasonable doubt, and they're not convinced that there's going to 100% convinced there's going to be a conviction, the grand jury is not supposed to indict. But again, that's nobody's business but the grand jury, so we really don't know what goes on with that and why they always decide what they do. That's the gray area of our legal tradition, and it's always been that way, and I'm not complaining about it, I'm just saying it is. But the indictment would give them, of course, power to do a lot of things they didn't have before. But no, they wouldn't need a grand jury to come in on a warrant and get evidence. All you need for that's a warrant, and the warrant has specific requirements to get a warrant before a judge, according to the Bill of Rights. The search and seizure clauses there are important. And certain things you have to prove to the judge. You have to prove that there's evidence of criminality and the place to be searched and the things to be seized. Now, when it comes to Mike and his fulfillment of the elements of fraud, he may have told, let's say, I'm speaking hypothetical, let's say that he said something to investors that wasn't true. That doesn't make it a lie. A lie is when you know it's not true and you're saying it anyway in order to get unlawful gain, to separate people from their money. From what I get in the case, though, there was not proof of that. Again, I can't second guess the jury, but there can be motions made, evidence insufficient for conviction. I mean, there has to be some evidence offered in trial that proves these elements, even if it's just a sliver. The jury comes back with a guilty plea and there's not one sliver of evidence that they can hang their hats on respecting one of these elements. Well, the court has the authority to throw the case out and overturn it, because that's, as our Constitution says, that's not operating according to the course of the common law. That's a conviction outside of the process, the due process, as they say, of our common law. So whether or not, of course, this is what people are looking at now, is there a possibility of overturning this case because of a structural process problem, not because of the merits of the case. Coming back to the proving the facts, the trial is a trial about facts. You're either proving or disproving, you're fighting about what happened, who done it, how they do it. Those are all fact questions. And the appellate courts are not in the business, or primarily not in the business of finding and telling us what the facts of the case are. They don't hear evidence at the appellate level, the appellate court, and then the Supreme Court of the United States. What they do is look at the record about what happened, and their job usually is to say, wait a minute, this wasn't fair. Wait a minute, there wasn't any evidence offered on this element. How could the jury find him guilty when there wasn't even any evidence offered? Well, there was a little bit. Oh, we see it in the transcript and the record here. In other words, if it's a structural problem, not a problem going to the merits, and that's what you want to focus on appeal, and who knows what could happen? Who knows on appeal? Back to you, Greg.
All right, we're going to go through the substantiation process that they put into these complaints, and then we'll get into the actual opening statements, where the broad outline, if you will, in support of their side of the case is presented by both the prosecuting attorney and then the chief defense attorney. And then we'll get into the case, and we'll start looking at the actual evidence that was brought forward by various witnesses and by the prosecution, and rebutted when it was rebutted by the defense. And I'd like this audience to act kind of as a jury in their own mind. Do you think that these 6 elements that we pointed out were proven? Do you think there was sufficient evidence to substantiate the claims against Mike? That's why we're doing this. And you're every bit as qualified to be a juror as anybody who was there. Last video, the first video, we covered why we felt that several of the folks that were chosen for the jury really weren't qualified as peers for Mike. They didn't have the experiential native capacity to judge him. They didn't have work or educational experiences or family experiences that were comparative to Mike's. And therefore, there were better, more suitable jurors that might have seen things differently or been less easily persuaded by the slivers of so-called evidence that were brought to the fore. Might even have picked up in some cases what was missing. Like, wait a minute, the prosecution has completely glossed over this issue and didn't present anything relative to that element. If anyone had pointed that out, the fact that the damage by everyone's admission, if they brought in all 500 lenders and paraded them across the front of the jury and asked them the same question, then that question should have been, were you harmed before or after the government's intervention? And I believe, and we all believe, that everyone would have had to truthfully say, I was fine. Whenever I asked for my money back, I got it in short order. Oasis didn't even require to wait the 90 days, which is, I had contractually agreed that they could. I wasn't held to bar to hold that. Everyone was paid. They paid out over $20 million in returns. Much of this wasn't brought forward, and much of it was just a gloss. It was an impressionistic painting, if you will, that people could look at in different ways. And without a very strong defense being put up and say, wait a minute, fellas, that isn't exactly what happened. And this claim of this particular element as represented is not actually true. And here's why. And much of that was missed, unfortunately. And now there's a good man in prison for 23 years if this is not brought to appeal successfully. Jason.
Yeah, and as we go along through these videos in the future, whenever there are some points, you mentioned the NFA, for example, there's other points that us here for sure know that there's facts that support the complete opposite of what the prosecution led on throughout the course of the case. Are we going to interject those facts and that evidence along the way so we can show, here's what the prosecution said, this was the argument that was made, here's what the defense said, but we know that this is the actual facts that support the defense in this specific situation or instance? Are we going to do that along the way in these videos?
Sure. You'll remember that we discussed in our first video that there were 336 documents created over the course of more than 2 years on the part of defense counsel working with Joe and John and Mike to compile that information. Of those 336 documents, only 101 found their way into the the case. It was only the only 101 were filed into the criminal trial. So what we can do, Jason, is to say, well, hey, sometimes it became a question of emphasis or a lack of emphasis on a key point, as you well know. There were many occasions when you would look at this and go, well, yeah, he just made a really great point, but he didn't emphasize it. And as everyone knows, quite often, particularly when there's something like this that's brand new to you as a juror, it's hard to get it until it's been repeated several times for emphasis sake. And I'll say this, that prosecution did an exemplary job of emphasizing their points, and the defense did an inadequate job of emphasizing sufficiently their points. So we can do that and say, well, here's a great point that was made, but not emphasized. And secondly, since we have access to it, we can bring in some of the evidence files that you and I are aware of that weren't brought to the forefront. Say, hey, you know, what would the jury would have thought if this had been put in and they knew this and it sort of missed. You've got to take it as Brent clearly outlined. You know, you don't know what a jury's thinking. You weren't there in the jury pool in the back room having discussion. We do know that there were other jurors, people who had backgrounds in law and accounting, that may have pointed out some omissions, some facts, and they could have, you know, requested that information, particularly in the grand jury. They could have done that. But yeah, we can raise those issues. Why not? I mean, this is an open forum, and I think that we should, and we will.
And the best part about it is we know that they're facts. We actually got the white papers to show it, or it's not a hearsay or speculation. What we'll submit is what's truly a fact, and it's not a speculation on our part that, like, hey, look, this could have possibly changed the trajectory of what went on here if this would have made it into the courtroom.
We will obviously be emphasizing things that were done and said, that were good and strong points by the defense that were not either well articulated or emphasized frequently enough to make the impression upon the jury that, hey, this is a key point. I want to emphasize this again and again and again every chance I had. Now, they had something like 7 lenders up there as witnesses for the prosecution, another 3 up for defense. Every one of them, had they been asked that one question, were you harmed before or after the government's intervention, would have said after. We had no problem with the operation of the company before. I think it would have made a great impact on the jury. Like, wait a minute, you just and talked, you know, for half an hour, 45 minutes about all the damage was done. Now you're telling us that it wasn't really done by Oasis or by Mike DaCorta. It was done somehow, and no one's going to ask you to articulate how, but it was done after the government's intervention. Oh, well, that would give rise, I would think, to some degree of hesitation on the part of the jury to convict. Remember what the standard was.
Correct.
Beyond,
and I know
beyond a reasonable doubt. So if anything, the defense had the job to create reasonable doubt.
And going further on with that is that the part with the whole NFA agreement, the prosecution made a very, very strong point throughout the entire trial with the whole NFA agreement, but yet the defense never brought to the point that, hey, the NFA agreement isn't relevant in this case. And that was one of the things that they made to look like, because they said that Mike wasn't sharing that with us as lenders. That made it to the jury look like he was trying to hide something whenever it wasn't even applicable at all. So therefore, that was one of the points that the defense missed out on. But the prosecution used that continually through the entire case. Even the defense never made the point that, hey, by the way, that NFA agreement you're making a big deal about, that's not applicable to this case.
And I would argue that the defense gave it more credibility by asking you and Kevin Johnson, who were witnesses for the defense, to read it. Well,
Correct.
why would they ask you to read the whole thing? And they would have had John do the same thing when he came up to bat third, until the judge said, "No, we've had enough of that. We know what that says, and let's not go through it again." That is emphasis, right? Is it not?
Yeah, but it was emphasis to the prosecution.
Right. Exactly. Yeah. Anything else? Brent, any closing comments? No? All right, then. I guess we can conclude for this evening, and we'll get back and do.
Oh, Greg, you'd asked if I had any comments. I wanted to make a closing comment, but my mic got turned off.
Okay.
I'm looking here at some of the affidavits that I had received from lenders, and they say things like, without giving their names, we received a package from the law firm Englander and Fisher about Oasis running a Ponzi scheme. That was news to us. We have no indication that there was any Ponzi scheme. We know nothing of Oasis doing anything illegal. The papers say we got false profits from Oasis. Of course, they didn't. Well, this is just over and over again. That's what the affidavit said. We sincerely do not believe the court had jurisdiction over us in this matter. We weren't doing anything wrong. He wasn't doing anything wrong. We have no information he was doing anything wrong. So why is this happening? They didn't ask that question because it's an affidavit, but yeah, this case, you see cases and you say to yourself, wow, I've seen a lot of cases. I've never seen one like this. I've never seen one like this. I've seen stuff that is similar, as they say here in the Wabash Valley, to this, but I've never seen one like this. This is massive, massive. And, here's another thing I can bring up, Greg. In order to do something like Mike DaCorta was doing, it takes a certain personality to even try to do those kind of things. You've got to be confident, you've got to be aggressive, and you've got to be, if you're going to be confident and aggressive, you've got to puff a little bit in your own mind. The law calls it puffing. Without people that are puffing, there wouldn't be any economics in America. I don't know how much puffing Mike did or didn't do, but there's no law against doing that. That's part of business, and our courts have always recognized that. I remember back when I was growing up, they used to have commercials that said, Cheerios will make you feel groovy all day long. Well, I ate Cheerios, and I didn't always feel groovy all day long. And I remember there was a lawsuit then later filed because saying that was false advertising. Of course, the courts threw it out. Why? Because puffing is part of business. A business wouldn't move unless people promoted what they do hard and try to sell people on things. The question then comes, where's the line crossed where it becomes a crime? Well, we've got it here in the elements of criminal fraud. Did Mike DaCorta lie? There's a difference between lying and puffing. Now, the prosecutors will say, well, puffing's lying. And well, that's not what our courts have said in the past, and they don't say that now. That's called, well, we'd say promotion, but I don't have a lot of evidence that he did that either, frankly. And if people want to invest until they've lost money and they start clamoring, I wonder why government steps in and confiscates massive amounts of wealth. What's their motivation? I'll tell you, it makes me wonder. I do know this: there are a lot of people making a lot of money off that money right now, and it's not the investors.
Right. That's
what's happening. That's called stealing. It's called abuse of the courts, as the law says, abuse of process, legal process. Well, these are just objective observations about what happens, and I wish it didn't. I'll tell one quick story here, if I may. A very well-known personality used to be Attorney General of the United States. He's still around, as far as I know. I found out how he got enough money to run for office. One of the ways he did it was he had a plum of a job as becoming a receiver. And he was a receiver on a number of cases. And to be a receiver is a fortunate position for the fellow that's a receiver. There's no question about it. And receiverships are lucrative for lawyers. That's the fact of the matter. Are there some receiverships that are justified? Well, I'm sure there are. They've been around for a few centuries. Sometimes there needs to be a receiver, but a lot of times there doesn't. And as government becomes more powerful and they push for receiverships, there's inevitably more abuse of such things. Well, again, I'm not making judgments about this case necessarily. I'm just pointing out my observations of the system and the way it's working. I've been around other receiverships and I've watched things being sold at fire sale prices. And that's not right either. And that happens a lot. A lot of things happen that aren't right. We don't live in a perfect world, but we do want to strive as much as we can to stop the abuse, to say, no, that's not right. And I see that happen in the Oasis case.
Mm-hmm.
Quick question, just real quick. Does the CFTC have the obligation to inform Oasis that it was being investigated? Or is that behind the scenes?
Well, that's behind the scenes, and until they've decided they want to say that they're being investigated. A lot of times, if something or somebody is under grand jury investigation, of course, that, as a matter of our ancient custom, is secret. Grand jury investigations are secret. Prosecutors don't want to blow the lid off things till they think they've got the net where they want it so the birds don't get away. That's their excuse, of course. And if there really is crime, I understand that. But there's no affirmative duty to tell anybody they're being investigated, no.
Okay.
But they'll do it sooner or later. They'll say, well, you're a target of an investigation. Then they may subpoena somebody to come in and testify before the grand jury. Well, sometimes they have different levels. This is the parlance they use. You can become a subject of an investigation, and then you move from being a subject, and they say, okay, now we've made this fella a target. That means they've got the crosshairs on you, and they're going to bring the force, in this case, the force of the United States against you, whatever it takes. Well, that's being a target is a bad position to be in. Being a subject of interest is bad enough. But no, they don't have any obligation to say.
All right, fellas, to avoid running on any further, appreciate very much your time this evening to compose this very important, I think, discussion about the elements of a cause of action, the cause of action in this case for fraud. And then everyone watching this going forward can judge for themselves whether the burden of proof was met by the prosecution and whether Mike received adequate counsel and assistance of counsel to prevent the conviction that he finally received or not. All right.
Sounds good. Nice to meet you, Brent. Good night, guys.
Thanks.
Looking forward next one.
Thank you, John,
Right.
Joe,
Brent.
Good night.
Jason, Greg.
Good night, fellas. God bless you each.
Good night.